Ladies and gentlemen, I regret to inform you that Alex Jones has messed with Texas. Or at least that's what the judge in Texas of his case seems to think. According to Jones, I've heard him say that what's happening down there, the trial, the procedures, how he's being treated, it stacks up poorly compared to Nazi Germany, which, at least according to some historians, had some significant flaws in the fairness of its judicial system during the Nazi reign. That seems likely to me. So really, it's that bad in Texas, maybe worse? I didn't know if you did mess with Texas that it would go that poorly. So is Alex Jones being tried in a star chamber, completely devoid of fair procedure, hidden behind a Kafkaesque bureaucratic nightmare designed to obstruct his due process rights? Or is there something more to this? Let's look. Jones has been sued in more than one state by several people regarding the Sandy Hook shooting and his comments and the companies he's associated with, the comments made there regarding the Sandy Hook massacre. And the causes of action include things like intentional infliction of emotional distress and defamation. And these cases, obviously the subject matter is intense. It's interesting from the standpoint of what can you do in this country in terms of free speech? Where's the line at? Fair commentary, opinion, malice. And when it's done in Texas's own kind of version of the anti-SLAPP statutes, the TCPA. Texas has a statute that limits punitive damages if you don't ask for a retraction, statute of limitations issues, lots of things that would, from a procedural standpoint, aside from what Jones said and who he said it about, and the actual incident itself, as horrifying as that is, from a law perspective, there were going to be a lot of things in this case that were interesting because he's certainly a person who's pushed the limits on this. Now, he feels like he's inside those limits and other people feel like he's not, but definitely he's on the border, right? He's on the frontier. Is he way past it? That was going to be the argument at the case. Now we see him on TV in a trial that is about damages. He's being deemed to have admitted liability on these claims. And the question for the jury is how much money, not whether you give money to the plaintiffs, but how much money do you give to them? They're asking for $150 million. I haven't heard yet Jones' team say a number that they think. The plaintiff's attorney seemed to suggest that we're going to go for nominal damages of $1. Let's hope that's not their strategy because I doubt that would be successful for them. But anyway, the number I've heard so far is $150 million. So how did we go from point A, he's sued, to point C, he's already liable and all we're talking about is how big the check should be? What happened in this country? I thought we had a right to defend ourselves and the First Amendment can protect you and you have all these other procedural things. Is Jones right? Is this worse than Nazi Germany? Would you be better off to be a defendant in Nazi Germany? Yeah, I don't know about that, but I am going to show you what happened and the fact that Jones still has rights under the law. He's acting like he doesn't, but he does. And therefore, even if the plaintiffs get the verdict they want at the damages phase of this trial, this case could still go on. Let's take a look. So between these cases being filed and the time that Jones found himself in the courtroom defending a damages calculation, there have been a lot of procedural things happen. The plaintiffs filed their documents. The defendants have made all kinds of motions to have the case dismissed, reduced under the anti-SLAPP statute that Texas has a version of. It's been up to the appeals court more than once. There have been sanctions orders against the defendants related to discovery issues in the case. They've been ordered to pay fees, I think more than once, certainly because the Court of Appeals has done it and the trial court has done it. But what ultimately happened is the trial court struck Jones' defenses and entered an entry of default, a default judgment against Jones. Well, how can they do that? So in most, I'm sure every state, there are various rules regarding discovery in the case, and that is your ability to take the testimony of other people, depositions and things, your ability to get documents and electronic data from other parties in the case or other people, third parties, basically getting information and evidence in the case. It's called discovery. And the idea is you play fair in that you provide the requested information. If it's a confidential issue, you try and work that out, or the court may enter an order that protects confidentiality. If it's a fishing expedition, you can argue, the court can hear that. But generally speaking, you're supposed to comply with the rules-based discovery process. And if you don't do that, the judge has authority to cause you to regret that. The judge can order the attorney to pay money. That's mostly what I've seen in the cases where I have seen it in discovery abuses. The court will order the attorney to personally pay the fine involved in the matter. The judge has this range of options available that the judge can order. So it can be money. It can be also that the facts that you didn't allow discovery on could be deemed admitted. Lots of things the judge can do. But the judge has authority all the way up to what Texas is calling death penalty kind of sanctions. Here's what it says. The judge can make an order striking out pleadings or parts thereof, staying further proceedings, or dismissing the action, or rendering a judgment by default. So if behavior is bad enough and it warrants it, the judge can either throw someone's lawsuit completely out, or they can deem you to not be able to defend it, that you have admitted liability, and let's move on to how much money you owe. Now that's, essentially the ultimate sanction the judge can do in the case, and you are then depriving a party of a trial by merit. So that's a serious issue, and it is a matter of law. It's not fact, right? So when you hear things are a matter of law, that's what you got appeals courts for, right? If a judge makes a mistake of the law or applies it at a significantly wrong enough way, then the Court of Appeals can deal with that, reverse it, or vacate it, or make whatever orders they need to make. So this statute provides that the appeal on discovery sanctions will be heard at final judgment. And I think in this case, the final judgment would be after the amount of damages is assessed. The judge will enter then the final verdict, final judgment, and then they can appeal this. So actually, this whole thing about him not having a defense, how can it not be the subject of an appeal after the amount is decided by the jury? So then it's going to rocket back up to the Court of Appeals, and these matters will be looked into. So Jones will have his defense that, hey, this judge abused her discretion, because that's how it's evaluated, abuse of discretion, in sanctioning me in this way, that it was too excessive. So first, I'm sure he'll argue I didn't really do anything wrong. But secondly, if what I did was wrong, and this is what I did, her response to it was disproportionate. So let's see how the court will look at that. So the trial court is executing its authority under the discovery rules, and that's going to be reviewed by the Court of Appeals, or whichever appellate court ends up hearing it, under an abuse of discretion. So the trial court has discretion in how it applies sanctions, etc. But that discretion gets looked at, I think, more carefully when you reach the end of the rope, which is the death penalty sanction. In other words, I'm not just going to charge somebody's attorney's fees or hit this fact or that fact. I'm throwing the case out, or I'm deeming you to be liable. So the Texas Supreme Court said that courts should avoid a, quote, trial by sanctions, end quote, whenever possible. Sanctions so severe that they prevent a decision on the merits are not justified except in the most severe cases of flagrant bad faith. So if you can't see where Jones's lawyers are going to start their appeal based on these statements, I don't know what to tell you. That's obviously it. So the Supreme Court of Texas is looking to see if the trial court considered the availability of lesser sanctions before imposing these death penalty sanctions. Is the behavior of the defendant such that the trial court could think their defenses don't have merit, or they wouldn't behave this way, that the failure of discovery is so egregious that I think from their failure to conduct it, they probably don't have anything there, and I'm tired of hearing about it, and they don't have any merit anyway. They also say in the case that the punishment should fit the crime. So they're looking for proportionality here. They're looking for, if you were 2 days late on turning over interrogatory responses and the judge throws your case out or deems you liable, you probably got a very strong appeal, right? However, in this case, the trial court has read these decisions just like I'm reading them, and certainly so is the plaintiff's attorney. So when the order is issued, it attempts to address these Supreme Court concerns, because that's what the Supreme Court is going to look at. It's going to look at, did you do these things before you impose this high level of sanctions? And Jones' attorneys are going to certainly say that they didn't, or that their recitation of having looked at these elements was pro forma, and if you actually look at what's on the record, that's not the case. But the trial court made a record of the basis for her decision. Let's see what she said. So the judge notes in her order that there was a flagrant and bad faith and callous disregard for the discovery process. She says this after reciting some of what she sets out as the failures of Jones and his team to comply with previous discovery requests and timelines, either in timeliness or in scope, that he didn't provide what he was supposed to provide. He wasn't providing what he was supposed to provide in the time frame either. And she says this has been an ongoing pattern. The judge then notes that this type of behavior has extended across the other cases involving Jones. So it's not particular to this case. It's not a misunderstanding in this case. She thinks it's how they're behaving across all the litigation in the state of Texas as well as in Connecticut. The judge says this is a pervasive and persistent abuse of the discovery process in general. She notes the defendant failed to provide critical evidence that this failure was unwarranted, and that based on this, she finds that there is a presumption available to her that the defenses that defendants have must lack merit, or else they would be engaging in this discovery. She then says, well, look, before I enter this default judgment, I thought about, well, what else could I do? What other lesser sanctions could I do? But she notes that prior to this, the court has made orders involving discovery sanctions, charged money, made other findings, and none of those things, in her opinion, have stopped the abuses of discovery. She also considers, hey, is this just a lawyer being a bad lawyer, and it would be unfair to Mr. Jones just to hit him with this? She says that the conduct has extended across a range of attorneys, that Mr. Jones has made comments that this is all show trials anyway. She sees a general bad faith approach to the litigation, that the prior remedies and orders that she's issued, they're not going to stop this from happening. So it's going to continue to make the plaintiff's case harder or impossible to make, continue to accrue to the benefit of the defendants, who have no respect for the process, as she believes they've said, and therefore unlikely to be swayed by anything that she says, short of just ending this problem. So Jones still does have his rights. If his case goes up on appeal and the court finds that the judge really should have done something less than this, it's quite possible that his case gets sent back down and his ability to defend himself is reinstated, and he can make all these defenses he wanted to make about the First Amendment and statute of limitations and other things like that. So that process is there. So if you're someone who believes that Texas is worse than Nazi Germany, then it doesn't matter to you, I suppose, that we have an entire process set up to evaluate the judge's conduct. But I tend to think that this is part of the process, that the judge doesn't do this routinely in cases, I'm sure, and then if she does do it, it gets to go to the Court of Appeals, where judges who aren't involved in this case look at it. More than one judge is going to look at it and decide whether this was the right thing that the judge did here. That's process. That's due process. You may not like it, and it is possible they'll make the wrong decision in it, but that's due process. I don't agree with comparing it to Nazi Germany. Now, Jones has said in other statements that we gave them everything they wanted. We gave them so many documents and so much information, and maybe that's true. But when you're the same person who's saying that the court system in Texas is worse than that in Nazi Germany, I don't know that I'm going to swallow on good faith and at face value your statements that you didn't violate discovery process and that you really were complying in that. I'm just going to ignore that part. I'm not saying it's true or not true, but I'm not going to trust you, because I think that's batshit crazy to say that the court system in the United States is worse or the same as Nazi Germany. So your judgment to me in how a court system operates, that's too impaired for me to believe anything else you say on that topic. Now, I would have preferred if this hadn't happened and it weren't struck, because like any other lawyer and American, generally you want the case to be decided on the merits. And Jones' case brings up a lot of good defenses that, whether they would be successful for him or not, they inform where this country stands on the First Amendment, where it stands on how much injury you can inflict on someone else while you're standing under the First Amendment. And shaping the parameters, that's always interesting to somebody who cares about freedom and process and law in the United States. So this case was going to speak to those issues, certainly. And now perhaps it's not. And what's worse about that is if the judge were correct and the Court of Appeals or Supreme Court affirms her decision to strike his defenses and enter judgment against him, you're still going to hear people say this was all about the First Amendment and he was denied, like Nazi Germany, to the ability to defend himself, when that is not what is happening in this case at all. It just is not what's happening in this case. Again, a judge could be wrong in how far she went, and there'll be a team of judges who will review that. But it's not like she said, I don't care about the First Amendment. I'm not going to let you talk about the First Amendment in this trial. I'm not going to let you defend yourself based on free speech. There was none of that involved in the context of her order. It was just over this discovery dispute. What she did doesn't happen a lot. Her order suggests that she saw it as the only course of action that she had to maintain equity in the case. And that's going to be reviewed again. So, unfortunate series of events in his trial. I'm going to end this by saying that if you have not watched the plaintiff's opening statement, though, in this damages trial, you really should. Whether you're on their side, whether you're on Jones' side, or you just don't know, it is sterling advocacy. If you turn it on, you won't turn it off. He did a fantastic job. It is a great opening statement. If you want to see what a fantastic opening statement looks like, maybe the best someone can do, you really ought to watch that piece. It's on Law and Crime Network. It's fantastic. Yeah, again, you can be a Jones supporter, but if you can't appreciate the craft there and how good this guy was, you're an NPC, so that's okay. It doesn't matter how good or bad somebody does. You're just going to think what you think. But if you're someone who's interested in the process of the law and the value of a good lawyer, I commend that piece to you wholeheartedly. It's fantastic. Thanks.